California's Courts, California Supreme. In this section, we're going to discuss the California Judicial Branch, starting with the first section, which is the courts. The courts are divided into three tiers: the Superior Courts, the Courts of Appeal, and the California Supreme Court. We'll discuss the California Supreme Court. The California State Court's highest court is the California Supreme Court. There is only one of these courts in California, and it seats 7 justices. The second tier is the California Court of Appeals. There are 6 California Courts of Appeals, where 105 judges are seated. And the last tier is the California Superior Court, also known as the trial courts. We have 58 of these courts, one for every county. And amongst their various branches, they house over 2,000 judges. Supreme Court membership and qualifications. In order to become a Supreme Court justice, you must be a member of the California State Bar for at least 10 years, or be a judge in California for at least 10 years. Be appointed by the governor. Be confirmed by the Commission on Judicial Appointees. Be confirmed by the public at general election. And be reconfirmed by the public at the end of a 12-year term. How, if you were going to go to the Supreme Court as a case, how would you get there? You can get there in 2 ways: through original jurisdiction or appellate jurisdiction. This works the same as it did in the Supreme Court of the United States. Original jurisdiction for the California Supreme Court is a little different from the federal branch. It still means that the court can hear directly rather than having to hear through appeals. It means that these cases can start at the Supreme Court and don't have to go to the lower levels. So the writ petitions would be mandamus, prohibition, which is a court order forbidding an act or activity, which is the writ of prohibition, or habeas corpus. And let's talk about each of these. Mandamus is Latin for we order. This writ, it's also called a writ of mandate, orders some sort of public agency to do something that it's supposed to do by law anyway. Sometimes the particular governmental body refuses to do something that it has to do by law, or it forgets to do it or neglects to. In that case, you can do a writ of mandamus in order to order that governmental body to actually do what it's supposed to do under law. Here are some examples. After petitions were filed with sufficient valid signatures to qualify a proposition for the ballot, the city refuses to call the election, claiming it has a legal opinion that the proposal is unconstitutional. The backers of the proposition file a petition for a writ ordering the city to hold the election. The court will order a hearing on the writ and afterwards either issue the writ or deny the petition. Of course, if the writ is issued, then the city will have to hold the election. If the petition is denied, then that will be the court saying that in this case, the particular governmental entity, so the city, didn't do anything wrong. Another example would be a state agency refusing to release public information. So say you have a housing authority, and the housing authority has their admissions and occupancy plan, and they refuse to release it. You can do a writ of mandamus in order to require them to release it and do a Public Records Act request in order to get that information. A school district charges fees to a student in violation of state law. Or a judge will not permit reporters' entry at a public trial. You can think of very many different state actors and government actors, and this is the way to hold them accountable for the things that they should be doing. Habeas corpus is a little different. What habeas corpus is, it's Latin for you have the body. And what a writ of habeas corpus does is it tells specific law enforcement officials, so not just the government, but law enforcement officials specifically, who have custody of a prisoner, that they actually have to come to court with the prisoner, and they have to tell the court why the prisoner is being kept. Why are we holding on to this person? So this goes for prison administrators, police, or the sheriff. And the idea behind this is that we don't want people held without getting some sort of charge at least, or any reason for why they're there. And so sometimes when we have prisoners who are held in detention and they haven't been charged, then a writ of habeas corpus will go up requiring the actual law enforcement official to come to court and tell the judge whether or not this person is lawfully in prison or lawfully in jail at that time. And the judge will make a decision from there. The writ is obtained by a petition to a judge. This has to be where the prisoner is actually incarcerated. So either in the county or the district, depending if you're on a state or federal system. And the judge is going to set the hearing, and then the judge will determine whether or not that person can continue to be held. Habeas corpus is a protection against illegal confinement. And here are a couple of things to think about when you're thinking about habeas corpus. Holding a person without charges, when due process obviously has been denied, when bail is excessive, when parole has been granted, when an accused has been improperly surrendered by the bail bondsman, or when probation has been summarily terminated without a cause. So this doesn't only have to be somebody's in jail and hasn't been charged yet. Just something like bail being excessive or parole being granted and the person not being released would be a reason to file a writ for habeas corpus. So let's talk about appellate jurisdiction to the Supreme Court. And of course, this is when the cases come up from the trial court level and they're brought up to the appellate court to review the trial court's decision. In this case, the writ petition is called certiorari. A writ of certiorari is an order telling the lower court, hey, send us up all of the documents and all of the what you've got on this particular case because we're actually going to hear it and take a look at it. So you file a writ to the appellate level, and the appellate level will then decide whether or not to require the lower court to send that information up to them so they can hear the cases. The appellate jurisdiction does not require that you hear all parts of the case. There can be an appeal on only one part of the case or on a few issues in the case. It doesn't have to be the whole thing. Another way that the appellate can come up to the Supreme Court is for the death penalty. Now, this is a little bit different in that when you have the death penalty, you get to skip over the appellate level. And so, while normally with the Supreme Court, you've had something from the trial court, that went to the courts of appeals, and they went to the Supreme Court, remember it's gone up through all those three levels, in this instance, you have a lot of cases which are coming up from the Court of Appeals, and you're reviewing it just as the trial court's decisions would be reviewed by the appellate level. But in this case, with the death penalty cases, they can be appealed directly from the trial court, superior court level to the Supreme Court. They jump over the appellate court level, so they jump from level 1 to level 3, and don't have to go through that appellate level because the legislature has decided that they're that important that we need to make sure that we hear them speedier, bring them up to their highest level of appeal as quickly as we can. So let's talk about Supreme Court jurisdiction. The Supreme Court also does a couple of other things. It adopts rules governing conduct of judges and rules governing the conduct of judicial candidates in campaigns. There's something called the Code of Judicial Ethics, and it's basically the rules of conduct for judges that they have to follow if they're going to continue to be judges. Things like they can't accept personal gifts above a certain amount, or they're supposed to conduct themselves in certain ways. The Supreme Court also has discretionary review of the Commission on Judicial Performance. In other words, so if there is something going on with the judge that they need to be reviewed, there's some allegations that they're not doing something correctly, that they're engaging in misconduct, then the Supreme Court can review this commission that takes a look at these particular misconduct allegations. They can also review recommendations of the State Bar concerning discipline of attorneys for misconduct. Attorneys have a similar code that they have to follow in that if they violate this code of ethics, they can be sanctioned or even disbarred by the State Bar. And there's actually a State Bar court which will decide whether or not they've acted appropriately. And so the Supreme Court can review that as well. And then the Supreme Court has also been given jurisdiction to hear appeals of decisions of the Public Utilities Commission.